So this is the webinar on the Indian Patent Office and Insider's Perspective. So I welcome both the panelists and I thank you for joining us today for this webinar. I'll introduce the panelists. We have Mr. Rohan Puriya, who is a renowned patent attorney, and we have Shri Devan Rajagopalan sir, who was the ex-head of the patent department of the Indian Patent Office, Chennai. So I request Rohan sir to take over and introduce both of you and take over the session along with Devan sir. Over to you, Rohan.
Kanchal. Yeah. Thanks, Kanchal. The audience, sir, thanks to GridLogix for providing us this opportunity and this platform to share our thoughts. Today, we are out here to discuss quite a lot of concerns and aspects that people have generally concerns over related to the Indian Patent Office, and I am really thankful to Mr. Devan Rajgopalan, who agreed to come over for this discussion. Very rare do you see a patent office professional coming on a platform where they are ready to share thoughts on what exactly happens within the patent office. What happens to an application within the patent office, how the processes are, what are the processes that are followed. These processes are pretty much still not completely known to a lot of us, though I have been in this industry for close to about 18 years now. There are certain things that even I learn. So today we are here to learn from Mr. Devan Rajgopalan quite a lot about what an application goes through once it is filed, how does it move, what are the various types of examination that happens during the process of after filing the application until it gets either granted or rejected, whatever the case may be in a particular scenario. So just a little bit of introduction about Mr. Devan Rajgopalan. He is an ex-joint controller of patents and designs of the Indian Patent Office, and a very, I would say, very beautiful career that he has had. He is an engineering graduate of the year 1982. By then, most of us would not be even born, I believe. He spent a good amount of time working with BEL, Bharat Electronics Limited, where he supported the Indian Navy for the products that were being supplied to Indian Navy from BEL. Then after, he worked with the Indian Patents Office for more than 3 decades. So he was active in the Indian Patent Office from 1990 until 2020. And I would say that that's a sizable amount of time. During those 30 years, not just the patenting system in India and the patent practice in India, but the patent office in itself has gone through sea changes, huge changes. In fact, I have been in this profession since 2004, and in 2005, when the accession of TRIPS came in, when the act was changed, then itself we saw a good amount of changes happening. I don't know, God only knows what all he must have seen during his tenure of 30 years, such a long tenure to spend with the patent office. And I'm sure he must have spent a lot of time with different kind of dealing with different kind of attorneys, dealing with different kind of patent agents, inventors, some grassroots innovators. So there's quite a lot that we will get to learn from him. And the plan for the session is such that there are a series of questions that I will be taking up with Mr. Rajgopalan, and we had initially opened registration of questions for this webinar. So we have few questions from some of the participants who are already there on the seminar. So we'll be taking up those questions, and thereafter, during the last 15-20 minutes, we'll be opening the stage for questions from the participants on the webinar right now. So rest assured, guys, it's going to be a very fantastic and very nice session where you'll get to learn a lot about what exactly happens to a patent application or an invention. I would not just say a patent application. What happens to an invention once it is filed at the patent office? So that's a lot, Mr. Devan Rajgopalan, for accepting the invitation to coming on board. Thank you very much, sir. So let's start with a short interaction that we're going to have. Sir, I understand that you've spent about 30 years with the Indian Patent Office. That's a sizable amount of time. The act changed various times during your tenure. The patent office practices has changed over these last 30 years. So how has your overall journey been of the last 30 years? How has the patenting system progressed? How has the patent office changed as such in the last 30 years? Just give us a little bit of insight on, how have things changed over the last 30, 35 years. Sir, over to you.
Yeah, thank you, Mr. Rohan. So before I start, I would request the participants who are there to unmute their microphone and give a clap by both the hands. Let me just see their presence. So I am used to talking in front of the audience.
Oh yeah, that's right, that's right.
Let me just confirm that a lot of people are there. Can you just all of you unmute and clap your hands? If it's possible, get up and clap also.
That's something that we used to do back in the day when we used to have physical seminars. Wake them up before the session starts.
I'll wake myself up also.
That's true, sir.
Yeah, I think I heard a few claps, but I'm not myself. Good.
Yeah.
Thank you. Actually, when I joined the patent office in 1990, I was posted to the patent office, Kolkata. Trained in as per the international patent classification and as per the Indian patent classification.
Sir,
Yeah.
I think there was some glitch. There was some technical glitch. The first part that you spoke, the mics were muted. Could you please repeat that? So sorry for that. So sorry for that.
I'm here clear, no? Better?
Yes, sir. Loud and clear. Loud and clear.
Yeah. No, that's right. When I joined the patent office in 1990 at Kolkata patent office, there were no computers. So we are totally handling the physical file, and we are using for research purposes the abstracts of the patent which is already published in the classified as per the international patent classification and as per Indian patent classification. That is the Indian patent classification also was there. We used to use it. So from that time, when I retired in 2020, it was totally paperless. So no physical files used to come to me, and the hearing was also on video conferencing mode. So there is a big change I experienced in the 1990 to 2020. So you can add to the questions, Mr. Rohan, then you can.
So that's interesting, So you are saying that there was a time when everything had a paper trail to it. So the good old times, the 90s, the early 90s, and then when you moved on, there were no. It was basically a paperless office. I mean, in fact, even today, the patent office is pretty much a paperless office. And one interesting aspect you've spoken out just now, and in fact, that's something that even I did not know, having been in this profession for about last 18, 20 years. There used to be an Indian patent classification system.
Yeah.
So that's something very interesting to know.
Yeah.
Indian patent classification system. So all we as the generation was already working on these domains right now. All we know of is an international patent classification or the CPC, the cooperative patent classification system, or the Japanese F1 terms, or the EPC. There used to be an EPC at one point of time, or the US classification. But we never knew that there used to be an Indian patent classification system. Could you please help us understand a little bit more how was it like the Indian patent classification system? That's interesting. Yes.
No, of course, there was a limit because now presently the technology is advanced so much. Then if you see international patent classification, we find B01C 5/22. That is narrowed down so much.
Right.
Whereas that time it may not be that much. You may be having a broadly some 20 or 30 classification. So that will be limited to that. Because technology was also that much not that much diversified. So we were able to classify. Still, in spite of that, we used to get a lot of citations even in those patent abstracts which are available. So that is a good time to read it, fill the paper, and do the things there. That time.
True. So the Indian patent classification was there until what time? When did it cease to exist?
Almost maybe another from 1990 to maybe another 10 years maximum I might have done it. Even after coming to Chennai office in 1995 itself, not that much it was used there. Okay, slowly it started reducing. In fact, when I came in 95 to patent office in Chennai, that time the first time I saw the computers in the patent office. First time they started using computers.
Right. And you said that you guys used to look at the Indian patent abstract. So was it like you guys were only looking at the Indian abstracts and you did not have access to the overseas patents at that point of time to cite as prior arts?
No, we used to get in a book form the published applications from the US PTO and UK PTOs. We used to get it. Yeah, that's also there.
So it was pretty much the kind of, when I started my career, we used to get those CDs of the Indian patents known as the ICASWA Series A or the Series B kind of. That's the kind of access that you had to the foreign applications, if I'm not mistaken, right?
Yeah. In fact, another thing is that time the paper gazette used to come to the patent office. So published gazette that to be available in the libraries. So applicant used to visit the patent office to see the gazettes, and there they were getting the initial publication, which was limited to the application number, title, and that applicant name. That is minimum data they used to get. But they also used to see what is called as a non-worked patents, which are patents which are not being worked, commercially worked. So that list also used to be available to the applicant. Yeah.
Okay, so this working non-working aspect has been there for ages. That's the means.
Yeah.
So there used to be a separate list of patents that were not worked upon, right?
Yeah, that's true. In fact, it was very useful for the applicants also to know who are the people who are working in their field by seeing that, or for even the rather the opponents also. So they can either oppose the patents or even they can get into touch with the applicants and work together also. It was useful that time.
Okay, interesting. So I would also take this chance to ask you that how has the process been vis-a-vis 2020? I mean, the day we are sitting today. What are the changes that has happened to the patenting process? Once you file an application, what are the various stages that an application flows through? What was it back in 1990s? What is it right now? So could you please just take us through the process that used to be there?
Yeah. The basic process was the application is filed by the applicant, then the processing done by the patent office, and then after the grant, the enforcement has to be done by the applicant. There are basic 3 steps. But I used to tell the applicants, in fact, I will tell you an incident which happened. When applicant came and told me that his patent has been granted. So I was very happy because normally people come and complain about the patent not being granted, or it has been pending for a long time.
So your voice
So when he
is
said
breaking.
patent is granted, can you hear me now?
Sir, I can hear you. I believe there's some network issue. There's no problem. If you turn off your webcam, should not be a problem.
Okay.
Hello.
Okay, yeah, I'm continuing.
Yeah.
So he came and told me that patent is granted.
Yeah.
So patent is granted. Then I asked him, then what further information you want? He said he wanted to file a patent in Europe. Then I was surprised. After getting a grant in India, he talked about filing a patent application in USA, Europe. Then I asked him, you should be aware that before filing a patent, it should not have been published. He said, nobody told me this when I filed an application 10 years back. I told him, okay, you are not aware here, but your corresponding application in Europe, you must have been aware. Then he said, in the group of companies around the world, his sister concerned, he is the first to file a patent application in India. So he said he is the only person more aware. So why I'm telling you this, so the more information the applicants are aware, it will help them in getting the filing the application in a better way and getting it processed. In fact, either what I suggest to people is either they have an IPR cell in their own firm or the institute and have an in-house person to assist them so that they can prepare and file the application in a better way. Yeah, Rohan, you can proceed.
No, that's a very valid point, sir. That's a very valid point. Having an understanding of what exactly needs to be done in order for a patent to file. You actually need somebody who's there in house, or you actually need to come across somebody or take support from somebody who can help you with such things. I understand that. So we were talking about the complete process of patent filing. You said that once the application is filed, probably it's published. So what are the other aspects apart from publication? How does it move further?
Yeah, the normal practice is once the application is filed, after 18 months it is published, then a request for examination has to be filed. So based on the order of request for examination, it is taken up for examination. And once the examination and search both are done by the examiner, and then in consultation with the controller, the report is issued to the applicant. And within a stipulated time of, for example, 6 months, the applicant has to meet the requirements mentioned by the patent office, clarify the things. Then accordingly, either patent is granted or refused. And in between, after the publication, the pre-grant opposition might find any has been filed, that also will be taken up and processed by the patent office. And every stage, the applicant will be informed, and he'll be given a chance to get a hearing if required. Then the final decision will be taken by the controller. Yeah, this is a brief step.
Okay. Okay. So you said after the patent is filed, there is a request for examination that has to be submitted. After the request for examination is submitted, then the patent application proceeds for examination. And you also said something in between that the patent is published after 18 months. So why this 18 months? Has this 18 months been there right from the very beginning? In the 1990s also it used to be like, once you file the application, forget about it for 18 months and then only it will get published. How was it back in the day?
In fact, in the 1990s, the system was slightly different. There is no publication immediately. As I told you, only the basic data will be given, application number and date and the title applicant. But after the application is processed, there was no request for examination also at that time. But once application is processed and it is found in order for grant by the controller, then it will be published in the Gazette as an acceptance notification. It is ready for order for acceptance, but open to the public to oppose any. Then there is no opposition, then it will be granted. So that is the procedure at that time. But later on, recently now, the system is once it is published, then it will be present for request for examination is filed. But why the 18 months is, the earlier also there is a time period of 12 months where between filing what is called as provisional specification and the complete specification. The 12 months minimum was given so that the applicant can improve upon the provisional specification and file the improvement together along with the claims within 12 months. So the another grace period of 6 months is given so that applicant can, in case he doesn't want to proceed further, he can withdraw the application itself, and because he makes major changes, so he doesn't want to file it, so he takes back the application, withdraws it, and then files it fresh. To take care of this aspect, this 18 months gap is given for the publication.
Okay. So if I understand correctly, this 18-month thing is recent, you're saying. It was not there earlier. The bibliographic data used to be published, it used to proceed for examination. Post the examination, there is an acceptance of patent that used to get published, and then a grant used to be published, right?
Yeah.
And then in back in the day, there was only a pre-grant proposition and not a post-grant proposition available to the opponents, right?
Yeah, you are right, perfectly. Yeah.
Okay. So the system has thus far gone through a change, and now there's this system where we say that a patent is published only after 18 months from the date of filing of application. Okay. Why this 18 months, sir? Why this 18 months? Because I have spent a good part of my career being an in-house counsel. Okay.
Yeah.
A good part of my career being an in-house counsel. I believe few of those guys who I've worked with when I was an in-house counsel, they're on the panel right now. And I used to get this question so very often. I can't tell you. I've gotten this question so many times. Why does a patent take such a long time to get granted? Why 18 months for publication? So I know.
We are living in you are living in an era of fast foods. Everything you want fast. So as soon as you file an application, you want a patent. So that is why now a new provision has been included to get it published within 1 month. But you have to make a separate request for it and file a prescribed form and the fees. Then the application will be published within 1 month. That provision has been recently added to take care of this request.
Yeah. Okay. Expedited publication. There is an expedited publication process that's available. Right. That's what you're saying. And that process is at a cost. That does not come with the regular cost of patenting. That there is an added cost to it that the applicant or the patentee needs to bear. Okay, that's interesting. And when see, like you said, there are two different processes. One is examination and one is publication. So examination starts after the publication is done. After the publication is done, the application goes through an examination process and then only it gets granted. So if I say that there is a
Correct.
separate
Yeah.
expedited publication process that's available, does that mean that it will also be examined in an expedited way, or there is a separate sequence for expediting the examination also?
So there also there is a separately make a request for early examination that can be taken up. Again, if they have prescribed fees and the prescribed form. So separately, you have to make a request for early publication or early examination. Both separately, you have to do it if you want it. Yeah. Otherwise,
And
normally
both
it is
come
the
at a
order of
cost.
request for examination. It will be taken up. Yeah.
And both come at separate costs, right?
Yeah, definitely. Yeah.
Okay, so imagine a scenario where somebody has filed, two people have filed an application. Say you have filed one application and I have filed an application. You filed an application and you filed the request for examination. Like you said, that there has to be a request for examination filed along with the application. So
Yeah.
we both filed
Or
the
within a
application.
particular period. Yeah.
Within a particular period. Okay. So necessarily you don't necessarily need to file the request for examination. At the same time, when you're filing the application, you can file it
Yeah.
within a period of 4 years from the date of filing the application.
Correct. Yes.
Correct me if I'm wrong. Okay. So imagine a scenario where we both need an application to be granted and we want it to be granted fast. We both file an application. We both file the request for examination along with the application. And you file for an expedited publication and I do not file for an expedited publication. So that means that your application will be published 1 month or 2 months at the max from the date of filing, whereas my application will be published after 18 months from the date of filing, the regular process.
Correct.
So in that scenario, will your application be examined faster because we both had filed at the same time, examination also filed at the same time? But is there a scenario that my turn for examination had come, but since the application was not published, my examination did not start, but yours was published, hence your examination started? Does that happen?
That is theoretically that is correct, but practically what happens is in the filing and the processing stage, based on the number of applications filed and the number of people available in the office, that scenario doesn't arise because mostly by the time the request for examination is coming up, your application would have been published. That is because that minimum gap always exists. So it may not happen. But theoretically, it's possible. What you said is possible. Yes. Yeah.
So I would say that the patent office has done the human resource management in such a fashion that your application cannot come up for an examination before 18 months.
No. When you talk about human resource management, I will tell you one thing. When I joined the patent office in 1990, all over India there were 40 examiners, 40 examiners all over India, and I was the 40th examiner when I joined, so in junior most. Okay. Now all over India there are about almost 600 examiners are there. Okay. And now so much of bifurcation of the fields also is there. So narrowed down. So things are moving in a much better fashion, more detailed way. Such an examination is being done now.
The examination is being done detailed. I would totally agree with you on that, because we have also been facing examination for a good amount of time. We see the quality of examination report has improved. We also see that it has started moving faster. A small question, maybe off track. Maybe I don't know whether you want to field that question or not. What do you feel? Is it up to the mark, or there is still a huge room for improvement?
Can you repeat the question? Sorry.
I'm asking, what are your comments as to the patent office, the way it is functioning right now, the way it was functioning earlier in the day? There is a huge improvement. I definitely agree. But do you believe that there is still a room for improvement, or is it working optimum? What's your take on that?
No, I will tell you one thing. My way of looking at it is like this. Is the quasi-judicial authority. Patent office is a quasi-judicial authority. It is like any other court, whereas we deal here technical as well as legal things. So we are following the procedures and doing things. See, like any other, I am talking as well. I am still in the patent office. I retired actually.
Right. Sir, your voice is breaking. So we are not able to hear you.
Okay. Office. But what I think is, as long as suppose you are going to file a good office, this will be the smoother fashion.
sir, we are not able to hear you.
Should I switch off my audio? Video?
Uh,
Can I hear me now?
No, yeah, now I can hear you, sir. Now I can hear you.
Okay, only audio. I'll choose. Yeah. Oh, organize. Okay. Okay.
Yes, sir. You were saying something. Sorry, sir. We missed it.
Yeah. No, I said as long as the preparation is done by the applicant side is okay, there is I feel things are going in the patent office. There may be small, human intervention is always there required in some places in the way, some corrections. But overall, I think it is correctly going. There's no issue. Unless you want to have specific queries, I can answer it. You can.
No, that's good enough, sir. That's good enough. So yeah, the patent office has progressed so far, I understand. Now let's come back to the patenting process. You said that 18 months can be taken care of if we file a request for expedited publication. Again, the process of examination, the examination can also be expedited if we file for an expedited examination. Now let's touch upon the examination process. What are the various kind of, and like you said in our earlier interaction, you don't like to use the word objection or rejection, because what we get from the patent office is actually called formal objection. But I would refrain from using that word.
Can I switch off my webcam?
Yes, yes,
Think so. Audio be better?
Yes,
Audio
yeah.
better?
Yes, yes. Maybe some patent issues. So I was saying that I will not use the word objection or rejection. Though the patent examination report reads out as objection or rejection, I would say that what are the kind of clarifications that are there in an examination report that an applicant or inventor receives? What are the various kind of clarifications sought by the patent office in an examination report?
No, yeah, in fact, I used to, of course, the office has to take the procedure or change the procedure or they want to think about it. But for example, in the USPTO, before filing itself, the applicant is supposed to do a prior art search and also cite the prior arts and then compare the prior arts and give the invention, how the invention is improved over the prior art. So if that is done, then the applicant also will be clear about how far his invention is crossing, will be able to pass the test of the search and examination to be conducted by the patent office. So that is one thing. So once it is taken away, then the remaining thing is nothing but you want to have a checklist of what are things. For example, in the formal examination, you check whether the power of attorney is filed, whether the proof of right is filed. The proof of right is mostly required when the applicant and inventor are not same. So whether that is done. Whereas in the technical side, whether the claims are written in the right way, whether the claims are worded as required by the Act, whether they are interconnected in the right way. So these are basic things which will be asked by from the patent office side. So when these are once this is taken up, then I think the rest of things will be really formal things. Yeah.
So you're saying that there are scenarios where you have seen that even the proof of right is not filed by the applicant with the application.
Yeah.
Or for that matter, sometimes even the power of authority has not been filed. The PO has not been filed.
Yeah.
So I personally believe that, when you talk about scenarios where the claims are not written in the right format, that can be taken care of. So you're saying something?
No, I just your audio did not come
so
for
if there's a problem
one more thing is
okay.
So one more thing is I said about prior art. The citations, because citations, the applicant has to modify the claims or the claims so that he doesn't infringe the other patents.
Okay. So you are saying that there are two different kind of requirements that are there in the examination report. One we would term as the legal requirements or the formal requirements. Okay, the legal requirements related to law, like proof of right is not there, the power of authority is not there, the format in which it has to be filed is not commensurate with the format that the patent office requires you to file an application in. These kinds of requirements. And the other requirements where you really need to look at the technicalities of the invention that you filed. You really need to technically differentiate the application that you filed vis-a-vis the prior art that has been cited by the patent office in the examination report. So clearly two different kind of requirements that come from the patent office at the time of examination stage. So now we come back to the examination stage itself. If I understood correctly, you said that if we really take care of the formal requirements, the examination will proceed much faster. Correct me if I'm wrong, sir.
Correct.
So,
Yeah. Correct. You are right.
So there are scenarios even when people have not filed the proof of right, stating that these are the specific inventors, and these inventors have filed for an application through an applicant, and these inventors have assigned the right of application or the invention to the applicant. That's what the proof of right is. Correct, sir?
Yeah, correct. Yes.
Okay. So you have also come across scenarios where the proof of right itself is not filed. Okay, so that's I personally believe that if people start filing through if people start filing through patent agents or attorneys who are trained in this aspect, these things can probably be taken care of. But then also you went there and said that there are times when the power of authority itself is not filed. Now that's something that we as patent attorneys need to go back and look at and rectify from our end. If this is something that's really hampering the speed at which an application is processed, this really needs to be looked upon at our end.
And so one more thing I would like to add here.
Yes.
Because most of the applicants who are technically working, they don't have extra time to devote to the preparation of the application, patent application specification to file in the patent office. In that scenario also, it is better for them to have an IPR cell and have an in-house person to assist them, so that their application will be in the best way filed.
Okay. So yeah, that's what you are also iterating, that you probably need somebody who's qualified to deal in these domains, so that these things can be taken care of properly, right? Okay, that's interesting. That's good. Now, coming back to the next aspect, where we say that the examination is being done and the prior art's being cited. How does it really flow in the patent office? Who really finds the prior art? How are the prior arts found? What kind of comparisons happen? What really happens there? Can you please enlighten us a little bit on that?
Yeah. Presently, we are using a huge database of the patents. Almost the entire world, that non-patent and patent literature was being covered, and the examiner is trained to do search on that. So he initially reads the specification, identifies the keywords, and also classifies the application as per the international patent classification. And then, in combination of the keywords and the international patent classification, he conducts search in these databases and tries to narrow down the number of citations as minimum as possible, as near as possible to the applications examined, and in consulting the controller, sends a report to the applicant. So that the applicant has to compare and then see from his point of view whether the examiner is agreeing with the examiner or not, and then give his clarification.
Okay, so you say that you guys are using a patent database to identify prior arts from. Is it a paid database, or you guys are using free databases like the European Patent Office database and the US PTO? What exactly is it that you guys are using?
Earlier we were using the free databases that was covering maybe say about 60% of the world patent document, but non-patent was not covered that much. So by using a paid database, we are trying to cover as much more. Their patent office is trying to cover much more, like 90% of that. 90%, almost 95% of the documents are published around the globe. So they are able to get almost the work of the applicant is almost reduced, because you may not get further opposition due to his thing, because it is already taken care during by the citation. That's why I was again reiterating, even before filing or during the process of filing itself, if the applicant does some prior art search, then it will be further useful for him. Yeah.
Okay. So, which paid database are you guys using? Are you comfortable in sharing the name of the database that you guys are using, that the patent office is using?
Now, I think, because I retired now 2 years back, I think they are using PatSeer, if I remember correctly.
Okay, interesting. So back in the day when you were working, were they still using PatSeer or they have started using recently? And how does it compare? I mean, I also understand that back in the day when we used to do searches, when we started our career, we used to search on the USPTO website, on the EPO website, and EPO we used to consider as the most comprehensive database source for us, source of information for us.
Yeah.
But now that so many big databases, we are also going to use to these things. So how do you compare these two things?
Yeah, I think the format of search definitely matters. So in my interaction with the examiners who do the basic work of searching, so they do have said that PatSeer was very user friendly and able to get more hits using the. It was more the way of searching was definitely friendly, useful compared to the other databases. With names, they didn't say much. I don't remember.
Okay, so it has made the examiner's life relatively simpler. Isn't it?
Yeah.
That's what you're saying. Okay, okay, okay. And now I would come back to the examination process once again, because examination process is something that bothers both the applicants, the inventors, and the attorneys equally. You said that there are kind of technical objections that come during the examination stage. What are the objections related to that? Let's touch a little bit on the technical objections. What are the related?
See, one is the consistency of the claims. The for claims are dependent claims and independent claims, how they are interconnected and worded properly or not, whether they are supported by the description. So sometimes may ask for something much more than what is described, whether it is supported or not, whether it is beyond what is described, and then whether the drawings are given clearly and then elaborated along with the description or not. Because unless the examiner is able to identify the invention by reading the description, claims, and drawing, it will be difficult for him to do the search in a better way. That's it.
Right. So you're saying that there are scenarios where even the claims are drafted, the dependencies are not defined properly in the dependent claims, and the drawings, there are some problems.
Actually, there are a few cases. Sorry to interrupt. Actually, there are a few cases where examiner says search could not be conducted because the way the things are drafted. You're not able to conclude what is to be searched. Yeah, maybe if you're not many, maybe a few cases at least. I mean,
no. Even if it is few, that's very interesting, because he probably is pointing out a scenario where you have drafted it something in such a manner that the examiner itself is not able to understand what is the intention that you're trying to claim. And unless he understands what is the intention that you're trying to claim, he'll not be in a position to perform the search. So, okay, so that's an education for people like us who are drafting patent applications, and a lot of people out there who are right now listening to us to this interview. That when they're drafting the applications, we ought to make sure that the dependencies of the claims are also defined properly, and the claim is written in a fashion that the examiner understands what exactly is it that you're trying to claim. Sometimes, in order to make it broad, we write it in a manner that actually the meaning is lost somewhere in the process. So yeah, that definitely needs to be avoided. Okay, now touching a little bit upon, I understand that there are examination reports that touch upon specifically the novelty and the inventive step aspect of patents. Okay, so when we get a lot of prior arts, the prior arts, the examination report reads that the instant application that you file lacks novelty in view of the patents that are cited or the applications that are cited, or it lacks inventive step. So when somebody raises an objection related to novelty, I generally, in my opinion, the best thing is you go back and say that okay, probably either the examiner has not really understood what is it that I have written, or if it is a novelty objection, probably the novelty resides somewhere else, and you are misunderstanding that the novelty resides somewhere else. If that's not the scenario, how do we deal with novelty objections, or how do we deal with inventive step objections? What is the modus operandi that you would suggest that can expedite the process of examination?
No, but again, coming to basics, the more documents the applicant himself sees from the time of starting the research, things definitely help. That is one thing. Secondly, the way we look at it, because like examiners, when they are trained, they are told, even through WIPO, we have been examiners have been trained. So they are given 3 steps for measuring the inventory step. For example, the problem may be very simple, but if the problem is existing for 20 years and nobody has found a solution, and even if somebody invents something very simple like a safety pin. Safety pin is invented long back. Now it looks very simple, but at that time the problem was there for long and people they invented. So even though the solution is simple, it may be taken as having involving inventive step. In fact, in the recent amendment of the Act and Rules, we notice that economic significance is another aspect which will definitely help in getting a patent, because there is another angle we look at it. Economic significance also.
Okay. Okay. So you were saying there are 3 steps, 3 tests that you conduct. One of them is the problem is long-standing. Second is economic significance. What else is it that the patent office looks at? What are the lenses that the patent office looks at through?
No, actually, all this in theory is one thing. If we come to the actual thing, because you will find that most of the patents are not breakthrough patents. They are all improvement patents. So when the improvement is very small, also you are getting. So even after getting a patent, you will notice that hardly 30% patents are actually worked now. Most 70% patents are paper patents. The reason is they are not able to, unless they are combined and utilized, they may not go to the next step. So that is again, in fact, this is one thing we'll need to repeat to that. In fact, in the other places, university industry collaboration is very much required to get back to the patent office in a better way, and then after getting a patent, also enforcement also will be easy. So university collaboration is something which should be done more, so that the university people can understand what are things required by the patent office, because normally they are aware of how to write a research paper, but in coming to patent specification, they are not able to fully get it. So that I think it should be given more. Yeah. So I heard that more of audience, some of the audience are in universities. I want to tell them that they should have an IPR and do it. Like.
No, that's right. That's right. The universities need to step up. The educational institution or the academia needs to step up to the cause, because that's where the basic research is actually happening. It's not the industries that do basic research. That's where science is being developed, is what I would say. Converting science to technology and infusing life into the science that is developed there, that happens in the industry, and a lot of times that happens in the academy also. But then I totally understand the aspect that you're trying to bring in here, so that the academia and the industry collaboration needs to happen, and they both need to understand. But then there's this other aspect that I see, and there's this general perception that's there in the public. Okay, and don't take me wrong on saying this, because this is something that I listen to very often, very very often. Yeah, when we file an Indian patent, it takes 5 years for it to get granted, 6 years to get granted. Why don't we file an India patent? So what has the timeline been? What was the timeline in the 90s, and what is the timeline? What is the kind of timeline that we look at today? Not the exact timeline, but some sort of a ballpark figure you can give, so that the audience sitting here understands that how has it moved and how can it probably improve further. What is the timeline?
Yeah, I will come to the timeline. Before that, I will tell you my personal opinion. Forget about patent office. My personal opinion is, you are applying for a patent. Okay, there are 2 things. You are trying to you are planning to work the invention either yourself or through somebody else. Okay.
Right.
So you try to work on it. See, there are a lot of, I've seen some applicants who have filed an application and then they have started working the patent itself. I mean, they started going to the market. Once it is published, now patent pending, they put and then start doing it. So that is where people have to concentrate. This is a procedure which will go on. I agree that it has to be escalated, but you have to, other aspect is more important. And here again, 18 months is the publication time, 6 months is the examination processing time, that is 2 years, and then to take up an examination, maybe that is where the time comes. So there, it depends on the number of applications filed and the number of people available in the office. So that again, I think nowadays it is very much reduced. Probably you may have to wait for 2 years maximum. So then again, once the processing started, again there may be some delays in some cases. That is again, for example, if we take biomedical example, there may be 10 examiners. Okay, but the application may be more filed. So that again, the
Right.
government is already trying to find out, and then they can, but they cannot decide in which field suddenly the inventions will go up. For example, electronics and communication, the filing is so much nowadays, and the pharma
Right.
also is going up. So nanotechnology applications are much more now. So to
Mhm.
overall, some calculation is made, and then the employee examiners controls are taken up. So that aspect will play a role. But the average, I think, 4 years is okay, as long as, because even if you are applying for a patent to work the invention, you require some minimum time to prepare it for the market. Because in a low scale marketing, lower scale, you'll be worked. But you want to go for higher scale manufacturing, it may take some time. So by the time you are set up, I think the patent will come. So this process, I think you can continue. There is no, I feel personally feel that there is not much delay in the processing itself, except maybe a particular case, maybe there few cases, may some reason it may get delayed. But once you interact with the
Mhm.
patent office, I think it gets sorted out.
Right. 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 Okay. So there's one more thing that you have told that that probably draws my attention. You're saying that once the application is examined, you're saying that once the application is examined, it goes to the applicant again, and the applicant has to respond.
Yeah.
Uh, so, are you trying to point out the aspect that if the applicant responds faster, the application, the overall processing would be fast? Because there are times when the applicant says that, okay, if I have 6 months time, I wait for 4 months, 5 months, and then I respond.
No, not
So
only
are you
for,
saying that? Yes, sir, say.
no, not only faster, you can grasp what is required by the office. Right? One term it will be over. Otherwise, again, the second term it will be taken up by the office and done. That is another aspect.
Mhm, mhm.
That's what I was telling, that the what is required by the office, if the communication is correctly going to the applicant, you can meet it.
Okay.
The things will not be delayed much. Of course, now sometimes I myself feel that 6 months is too less for the applicant to reply. But if he is already ready with the application, what is to be filed, then things will not be take that much time. That's all. Because earlier we used to have 18 months time for the applicant, but maybe 20
18
years
months.
back we had 18 months time for the applicant. Now it reduced to 6 months. So it
Okay.
again depends on the applicant to prepare himself ready and then keep it. The patent office may delay for say 1 year, so applicant is getting 6 months. So that time we can utilize it correctly and then do it. Then I think things will be better. Because why I'm telling is, again, there are applicants who miss out the timeline. The entire energy is totally lost, because whatever the efforts they put will lost because they miss the deadline, and there's no provision to get back again. There is no, like unlike in courts, you cannot pay some petition and then push the case back. No, there is no provision at all. Once you miss the deadline, it is missed. So the applicant should be careful in that also. That is happening in some cases I have seen.
Okay, okay. So you're saying that sometimes the applicant itself is not attentive towards what is happening with the application, and
Ah,
these also hamper the prospect of getting a patent application granted in an
yeah.
expedited manner. Okay, okay, okay. Fair enough. Fair enough. Uh, okay, now let's come to the stage where we said, okay, our patent is examined. We are through with the examination process. What happens post that?
Yeah, once the pre-grant opposition is already over, so once a patent is granted, it is open to our post-grant opposition. Within 12 months, anybody can oppose, post-grant opposition can be filed. So that will be, if it is filed, that will be taken up separately. So as long as the applicant is concerned, he is to take up, look for this notice, anything notice comes, he has to look for. In addition, he can go for the working of invention, he has to inform the office. If it is working or not, he has to keep the office informed every year. That has to be taken by care of by. In fact, as I told you earlier, gazettes used to inform us. Our
Right,
office
right.
is published. Now they have to do it.
Okay, okay. So you are saying that the information about working of patent is to be submitted to the patent office, and it is a
Yeah.
mandatory part. What happens if I don't inform the patent office about the working of patent?
So there is provisions for giving penalty and all. So I'm not sure how far it has been implemented. So the penalty is there, and that can be ground for non-working, can be a ground for revocation also.
Right, right.
And they're not.
Okay,
Rohan,
okay.
hi. Uh,
Hi.
Tushar here. Rohan, there are
Yes,
some
Tushar,
hands which
please.
are being raised to ask some questions. So would you guys be willing to take those questions now?
We would be coming to those questions. Just give me 5 minutes. I think I am pretty much I see a lot of questions coming up. I understand that people have a lot of curiosity. And with Mr. Devan here, they would be asking a lot of questions. It was something that I anticipated.
Very nice to hear.
So I believe with that we have come to the end of the complete life cycle of how a patent travels through during the its tenure as being an application to either being granted or rejected. Really sorry for that, yeah. So the thing is, I was talking about there is an intimation that has to be sent to the patent office suggesting that okay, I'm going to attend the hearing.
Correct. Okay.
Is that a mandatory part, sir? What happens if I fail to inform the patent office that I'm going to attend the hearing?
It is actually, there are some places, some hearing it is mentioned specifically in the act or rule, but some places it is not mentioned. But in general, I think it is better to always, just a mail will always help the controller to prepare himself that on the day whether you are coming or not on the hearing. In general, I think it will be helpful. So information is always better. Okay. Mutually, yes. Okay. Because to tell yourself that you are going to the patent office for that day, to confirm that to the controller that there will be hearing that day. Yeah, accordingly, we can plan. Because in a day, sometimes controller give 10 hearings also. So you can always be prepared for that. Okay. So you're saying that, and nowadays the patent hearings are online, sir. So we don't really go to the patent office these days. But then I know virtually you're going. Yeah, you're virtually going. True, sir. You're virtually going to the patent office. So yeah, with that, I believe we'll get into the question and answers from the attendees. Take the questions from the attendees, and start with that. There are quite a lot of questions, I must say.
Yeah, there are many questions actually.
Okay, I'll start with the first question. Can you give idea as to, okay, there's a question from Ekta Prasad. I think we answered this during the session. Can you give an idea? Can you give us idea how patent office reacted when India became TRIPS member in 90s and the transition time? So, sir, the question is, can you give us idea? Can you give us idea how the patent office reacted when India became compliant to the TRIPS? India became a member of the TRIPS vis-a-vis the 90s. Hello.
Yeah, Rohan, you are audible.
Sir, did you get my voice? Did you hear what I'm asking?
Devan, sir?
I don't know. He is there. He's showing there in the meeting. So Ekta, just to give a brief answer to you on this.
Type the question.
The way the sir.
Type the question. He's saying. Type the question.
Type the question. Okay.
You can copy paste it probably.
Okay. How do I do that, Tushar? Sir, I have sent you the question, so you must be in a position to see it now in your chat panel.
Not yet come. We do not come yet.
Sir, just open the attendees panel, the drop down, and click against any of the question mark that comes in front of any of the attendees' name. The whole question panel will open for you.
No, the chat box is open for me, but nothing is there in the chat box.
No.
Rohan, he's audible now. You can ask the question now.
Okay, sir. It asks, can you give us idea how the patent office reacted when it became when India became a signatory to TRIPS?
But I didn't get what is the background of the question. So
The background of question is how India reacted to being signatory to TRIPS. How the patent office reacted.
India joined many agreements from the time onwards. So what specifically wants to know? I'm not sure. It's about the history of the history. I'm not aware fully.
Not really history, sir.
Like
She probably
PCT,
wants
Paris
to.
Convention, so many things India joined from the time onwards.
So what is
You
it
can
that
answer
India
if you
did?
are clear about the question. I didn't get what exactly you want.
Yeah, so Ekta, there was a lot
India
of changes
amended the
that was.
act accordingly wherever
Yes,
required.
it amended the act. Absolutely, sir.
Yeah,
So
but a
there
lot of
was.
major changes are made in the act and rule. See, even the request for examination all started that time, no? Early
Right, sir.
publication,
Right.
request for examination,
Absolutely.
the different states start.
Absolutely.
18 months publication, yes. Yeah.
Post-grant opposition came into picture, request for examination came into picture, the 18 months timeline came into picture. So there was a huge change that was made to the Patent Act in 2005, the Patents Amendment Act 2005. I would suggest have a look at that.
Yeah, correct.
You'll get a fair amount of idea. Especially, I believe the 2005 Amendment Act was specifically pointed towards the changes that needed to be made to be compliant to TRIPS. So
Yeah, because India has given
now
about 10
I
years
have a
time to
question.
do that. Yeah.
Right. Some 10 years time to get compliant with those requirements. So now I have a question from Vishal Sudan that says, why is it mandatory to obtain prior permission from the patent office for a foreign patent filing?
Because the invention may be belonging to defense or atomic energy. So the
Right.
secrecy of Indian thing, we should not go outside India. That is the reason. Yeah.
And that also answers part of your question, Vishal. Why is these 6 weeks? These 6 weeks are taken by the patent office to look at it from the perspective of whether it has something related to the defense application or it has something related to the atomic energy application. Probably if that is the scenario, it is sent to the requisite authorities to take their views on those. And that's when, it comes to you and says that, okay, fine, whether it is good to go ahead or not good to go ahead. Okay. Now we have a question from Girish Kunte. Sir, nowadays we see the patent office objecting to the use of terms like at least one or about in the claims. Could you let us know whether these terms are to be avoided while drafting? Girish Kunte. Sir, would you like to take this question or should I take this question?
You can answer. No issue. Yeah.
Girish, I'm sorry, sir. I'm just transgressing a little bit. Girish, the whole thought process behind drafting a patent application is the claim should be definitive. Okay. You cannot have a claim that is not definitive. So when we say the word definitive, that essentially means that it should be absolutely defined. It should define the invention clearly. When you use terms like at least one or about, that leaves a lot of room for play. At least one, so it should be 1, 2, 3, 10, 100, 200,000. How much should it be? So that's not defined. The patent office would not consider that to be defined. So there is a issue related to definitiveness. That's why not using such term is actually what is advised. That's the same case when you use the terms like about. Correct me if I'm wrong, sir. Correct me if I'm wrong there.
You're perfect. You're perfect.
Thank you, sir. Thank you. Next question is, more rejections are seen under section 3K. Any particular reason? How do we overcome 3K rejections? Sir, would you like to take this question?
If you want me to, otherwise you can take.
I would prefer a patent office professional answering this. 3K rejections.
See, my answers are always very vague, very vague. It will be always. See, section 3K says, if I remember correct now, mathematical method or algorithm, computers. Okay. See, nowadays everything is using some software and hardware. So anything related to software alone definitely will not be patented. But it can be combined with the hardware. There is a possibility that it will be allowed. That is as simple as that. But depending on the particular application, the decision will be taken by the patent office. Any specific queries, you can come back to me individually also. I will try to clarify. Or through INOPAs. Yeah.
Yeah, either ways. So, Swapna, the rejections related to Section 3K are coming because, there's a lot of invention that's happening in that region of computer programs, and people are writing computer implemented methods, computer process products, CPP claims, CRM claims. That's why Section 3K rejections are coming. There are specific ways of drafting in which you can overcome 3K rejections. Now, I have a question from Shilpa Gurjar. Could you put some light on Section 8 and Form 3 filing? Do we need to file it for 6 months even if the status is unchanged? And do we need to attach the examination report from different patent offices for filing Form 3? Sir, somebody is asking the Form 3 requirement and Section 8 requirement. Even if the status is unchanged, no foreign filing is done. Is it necessary to file Form 3? Sir, Devan sir is not connected to the. Sir, unmute yourself.
Oh, okay.
Yes,
Okay.
sir.
So
Yes,
your
sir.
audio, I didn't get what is it? Okay, anyway, the
Yeah.
others might have
So,
no problem.
so somebody is asking a question as to Form 3 requirement, Section 8.
Okay.
Even
So
if the status is unchanged, no foreign filing is done, is it mandatory to file Form 3?
can you repeat the question again? What is it?
The Form 3 requirement, sir, even if the
Yeah.
status of foreign filing is unchanged, do they still need to file Form 3?
So you are supposed to update the patent office as to what is happening. So if there is no change, it is no requirement. But if there is any change, definitely you have to update. That is it. Yeah.
Okay. So I hope that answered the question, Shilpa, for you. Next question we have. Typically, what is the time period we should wait for before we send the email or contact the patent office if we have not heard back after the hearing? So she's asking that she has attended a hearing and the
Okay.
examiner has not.
Maybe 1 month you give. There is no issue. Unless you are very hurried. 1 month you can give for the patent office. Because some depends on a particular case. For example, you take a drug case, for example, there is a pre-grant opposition also filed. Then it may take much more time. The applicant control may take few months also to do it, because he may not be handling one case. At a time he will be giving 10 hearings in a day, so he has to take decisions. So sometimes there may be, but it's better to remind. There's nothing wrong in it. You can send a reminder. There's no issue. Make it polite.
Okay. Okay. You can follow it up, Swapna. You can follow it up in a soft manner. Again, it also depends on the. I hate to say this, but it would also depend on the kind of interaction you're having with the controller at that point of time. So, next question is
Let us
from.
be open-minded and be positive.
Right, sir. Right. Absolutely. Sir, people like you are few and far in between. Very rare to find, I must say. I've been having interaction with you very often, but then people like you are very rare, I must say that. Okay, now we'll move to the next question.
Don't talk about my colleague like that.
Ex-colleagues, sir.
Ex-colleagues now.
I mean, they are fairly good. They are fairly good. Most of them are good. But then, there are few people everywhere.
No, I am ready for any queries, any doubts. You can call me anytime. I'll try to clarify things.
So you have that, Swapna. People like you, if you have any specific queries, Devan sir is available. He's there to help people, and he's actually helping a lot of people in this place that he's staying in Chennai. He's actually helping a lot of people around there to understand and overcome such issues. Now we have next question coming from Ishwar Venkat Subramaniam. I feel that the quality of patent agents exam in India can be improved and it can be made much more tougher. For example, the European qualifying exam is very difficult to crack, 4 papers in total. This will improve the quality of patent agents in general. What are your thoughts on this, sir? Yes, sir.
I should answer?
Yes, sir. This is specifically for you. I am a patent agent. I can't answer this.
Yeah, I got a suggestion. You please send your mails to the Control General Office or to the Ministry. You can say there is I think there is government of India is nowadays open to, they have taken an initiative to educate even the school students about IPR. Okay, so they are taking a lot of initiatives to spread the awareness. So the more interaction you give, then it will be taken in a positive way, and then it will be placed for all the benefit of all. So please interact with the Controller General Office. You can write to them. I think that will be good.
Okay. Okay. So yeah, Mr. Venkat Subramaniam, you have a suggestion from sir. We can pass on these suggestions to the Controller General, to the CG's office, and see how it changes things. That's the kind of questions that we had. If there are any specific questions that the audience wants to ask, you can unmute yourself and ask your specific questions. Sir, I would at the same time request you to please put your contact details, or you can contact sir through me or GridLogics, either of us, for any specific queries. Now this
email,
is.
you can share.
Yes, sir. Sure. I'll share your email ID, sir. I'll just share sir's email ID on the chat. Give me a few minutes. And now I think now we are done with the questions that we received on the chat. If there are any specific questions, people can unmute themselves and directly ask the questions. I think with that, we come to an end to this session. Tushar, I hand it over to you.
Rohan. Yes. So thank you so much, Rohan and Devan sir, for this wonderful inputs today that you gave through this webinar. And I want to tell all the attendees over here that we'll be coming up with more and more interesting topics on various aspects related to IP. So stay tuned till our next announcement for the new topic and new webinar. Thank you so much, everyone. Have a great day ahead.
Thanks, guys.